Hello and welcome to Newscentre. The big story this evening, India has a new labour law regime in place. 29 colonial-era laws have been repealed or rationalised into 4 new labour codes. The stated aim is to modernise the legal framework, extend social security to a wider workforce and ensure universal wage protection. However, trade unions affiliated with opposition parties have announced nationwide protests. So how do the new labour codes change the landscape? Let's focus on some of the big changes. First, the central government will be fixing what it calls the floor wage, taking into account minimum living standards across geographies. The states, however, will have the power to fix the minimum wage rate, which shall not be lesser than the floor wage fixed by the centre. Second, and this has been a major bone of contention for trade unions, the law gives smaller companies more flexibility when it comes to laying off workers. Companies that employ more than 100 people needed government approval before layoffs. That threshold has now been increased to companies that employ over 300 people. Third, the gratuity eligibility timeline has been eased as well. Fixed-term employees who have completed a year of continuous service are eligible for gratuity. Earlier, the provision mandated 5 years of service. It also has a new code to give gig workers legal recognition. This had been a long-standing industry demand. Platform companies could see limited short-term financial impact. Another interesting policy change is the introduction of night shift for women, provided they can give their consent, and adequate safety measures have to be put in place for women. This ensures that female workers have equal opportunities to earn higher incomes in well-paid roles. In addition, there is now a mandatory requirement for women representation on grievance redressal committees. Meanwhile, several trade unions have protested against the codes, calling them anti-worker and pro-employees. In a statement, 10 central trade unions and various independent federations called the move a deceptive fraud committed against India's working people. Joining us to take this discussion forward is Jyoti, Director General of industry body FICCI, Ramani, Dathi, CFO of Team Lease Services with us, and Pooja, Ramchandani, Partner, Employment and Labour and Benefits at Shardul, Amarchand Mangaldas. Let me go across to Jyoti first. Jyoti, do you feel this helps the ease of doing business? The industry had always spoken about the need for labour law reforms, but does this come as a benefit? Is this going to help working in India?
So, good afternoon, everybody. So this is a very balanced act, what we have studied. It does, of course, bring in the ease of compliances. It uses the technology for surveillance. It does have decriminalized a lot of provisions, etc. So I think to that extent, there is a lot of simplification, ease of doing business, decriminalization for the industry. But at the same time, I think there are a lot of good things which have been done for the worker welfare, for the worker safety, for their safety and for their social security as well. And I think that brings in kind of a holistic a labor law which has good for both employees and employers going forward. Even you talked about the women worker, but I think one of the biggest one is for the gig workers, given that India has a large percentage, almost 90% in the unorganized sector. Gig worker, the platform worker bit is only expanding. Going forward, it's going to be a very important one. So bringing them into the organized fold, getting all the informal worker into the organized fold, into the social security network, I think that's a very big one. And that will give a lot of credence to our employment numbers going forward.
Right. Let me also go across to Ramani Dathi, CFO of Team Lease Services. Ramani, if I were to ask you about what happens to your take-home salary? Does the take-home salary now come down? Do expenses of companies, when it comes to retirement benefits, gratuity, provident fund, does that increase now?
Of the companies over the last few years have already corrected their CTC structure to align with the indicative labor codes. So many of the large organizations have already increased the PF contribution up to 50% of the total CTC. For those companies, there may not be any significant change in the CTC structure or any reduction. in the take home of employees. But having said that, that's a very small percentage of companies that we are talking about, especially the MSME segments and startups and other organizations where they have capped the PF contribution. So there can be a significant reduction in the take home salaries of the employees, both on account of PF and gratuity incremental provision. The companies may also have a higher CTC impact on their P&Ls. The short answer, yes. So there can be an impact on the take-home salaries.
All right. Do you also believe that there would be certain aspects of these labor code which will be difficult to implement, and you would want to seek some sort of clarification from the government, especially points related to overtime work?
Yeah, not just the overtime work. In fact, since labor is a concurrent subject, which is governed by both central as well as state laws. So while these 29 central laws have been codified into these 4 codes, how are the states going to have the operational framework to implement these labor codes is also a big question, because in India, many state laws are different, be it across minimum wages or ESIC and many other regulations relating to labor laws. So how would the framework work? Because will all states go together, or will there be a staggered implementation across states? How long it would take? So this, at this stage, we are seeing this as a primary issue in terms of overall clarification on implementation of labor laws. And also, as you pointed out, on overtime computation, how it is measured and how it is computed. So even that, on that part, we need more clarification. We are expecting that in the subsequent notifications from the government.
Right. Let me also go across to our other guest, Pooja Ramchandani from Shardul, Amarchandas. Pooja, when it comes to setting a floor wage, how difficult is this exercise going to be? And how do you think the centre can come to a conclusion? And do you think this floor wage will have to be annually revised?
Thanks, Parikshit. A very interesting question. So setting off the floor wage is going to depend on various factors such as, the geography, the demography, and what is the earning capacity and the extent of consumption per family. So these are the aspects on which the government is going to look at to, look at what the floor wage is. There is a possibility that this will need to be revisited depending on how things move forward. It's an evolving world that we live in. Expenses are increasing, and that's something that one will have to keep in mind going forward. And I believe that the government will probably go back every once in probably 5 years, if not shorter, to look at where things stand in terms of floor wage, as that forms the threshold for the states to prescribe their own minimum wage.
That's true. Let me go back to Jyoti Vij once again. Jyoti Vij, from an industry point of view, are there certain clarifications that FICCI would seek from the government? These new codes would, of course, have some impact on companies that employ gig workers, because you have to now give higher social security benefits as well. Are there certain clarifications that you're seeking? Jyoti Vij, you're on mute.
So while we'll go into the nuances of the, the details of the Act, codes, but FICCI was the one which had propagated the need for having social security for the gig worker, for the platform workers, etc. We worked extensively with the government to kind of, look at this aspect. We've also talked about it at the international platforms, etc. So there's been a lot of work we have done along with the platform operators to see that, this is something which should be considered and be brought into place. So I think it's a very positive factor. That's how we have seen, because this will, like I said in the beginning also, it will help in formalization of the workforce. I think there are a few areas where probably we'll also look into, some clarifications, like, Pooja also pointed out on the minimum wage, etc. Across the states, is it going to be differential? But obviously a floor has been set. So that much kind of, is very clear. And many aspects of these were known to us. So, we've been working on it for a while. And hence we see that, we're almost kind of ready to adopt this and go forward.
All right. Pooja, if I were to ask you about the ripple effect of this, are these codes going to impact all sectors uniformly? What about those in the unorganized sector? What about those working in construction sites? What about agricultural laborers for that matter?
So yes, the code is going to impact across sectors. And if one looks at, the 4 different codes, what it does bring about, which is new, is that it talks about social security for gig workers, social security for unorganized sectors. While there was a law on unorganized sectors and their welfare benefits, which has been subsumed here, by virtue of these codes, there will be an impact in terms of the types of welfare schemes that the government proposes to put together. There will be provident fund for unorganized sector workers. There will be welfare schemes in terms of insurance, accident benefit, pension even for gig workers. So in terms of unorganized, there is a whole stream of schemes and welfare measures that the government is looking at for the first time for gig workers. If you look at different industries and how it's going to have an impact, with the increase in these thresholds in terms of, the number of workers required in order to, retrench or close a factory, that has increased, as you mentioned earlier on, from 100 to 300 under the codes. Now, that is going to impact, those who fall under what is currently Chapter 5B of the Industrial Disputes Act and will find its way into the Industrial Relations Code. Where this number has increased for factories, mines, and plantations primarily. This is the number threshold that required an approval for the government, but not the non-manufacturing sectors. So now, with this increase in the threshold, restructuring would become a little more easier for the employer. In terms of, employees, one has to look at it from the perspective of what benefits that comes with any sort of restructuring. The employees, as usual, are protected. There are retrenchment compensations that are given. There are other measures which organizations already take when there are restructurings. So, as to answer your question, ripple effect, yes. Across industries, yes.
All right, we're going to take a short break at this point, but we'll request all our guests to stay with us. Lots more on this. This is a very important topic for India's workforce, and clearly we will be putting all those questions we've been getting through the day to all our guests. Stay with us. We'll be right back. Welcome back to Newscentre. Still with us are Pooja Ramchandani of Shardul Amarchand Mangaldas and Jyoti Vij of FICCI and Ramani Dathi of Team Lease Services. Ramani, if I can ask you about the minimum working hours. Now, the working hours remain capped at 8 hours per day, 48 hours per week. Has anything changed from previous clauses in the labour laws about minimum and maximum working hours? And if you were to work beyond that, do companies need to compensate that mandatorily?
Yes, Parikshit, as per the notification that we currently have, so there has been a flexibility that has been brought in terms of overall weekly number of hours of working that has been increased from the current level, which is 40 hours per week to 48 hours per week. But at the same time, for any overtime over and above this 48 hours, the minimum wage to be paid has been 2x of the base wage. Earlier, under different provisions, it was 1.5 times of the wage or 2x in certain cases. But now it has been streamlined that it would be 2x of the base wage for any overtime hours that are being spent.
Right. But Pooja, do you feel that this is going to be impacting all professions? What about doctors for that matter? What about those working in the electricity sector, in the power sector, essential services, police, media for that matter?
Right. So I think the first thing to know is that overtime is for, firstly, someone who is an employee. Second is that what the code says that every employee for which employment minimum wage is fixed, minimum rate of wage is prescribed by the government, would be entitled to overtime. So these are two factors that we have to keep in mind, which is slightly different from what the current law is. If I talk about what the current law is, the overtime is prescribed under the Factories Act and the Shops and Establishment legislations. Shops and establishment legislations across many states exclude those in managerial and managerial capacity and supervisory capacity and those occupying positions of confidence. So entire sector of classification of employees are outside the scope of the Shops and Establishment, which prescribes overtime. Now here, when we come to the labor code, we need to see how the minimum wages are prescribed. I would, take a cue from here that very senior management level or CXO level employees would still be out of this scope because historically, as we see that, minimum wage, when it is prescribed for skilled, unskilled, highly skilled and such. And that's the way the code also has sort of prescribed different category of employees, at least, when we look at the draft rules, which might, be out for circulation again.
All right. So that will be possibly a clarification that we will need. But let me also go back to Jyoti Vij. Jyoti Vij, now that this labor code has been implemented, there are 45 days for the industry to start implementing. The government also has to notify the rules. What more do you think can be done by the government to make labor laws easier to work with for the industry? Because the focus of the government right now is to think about how to make it easier to do business, how to open businesses easily, how to shut down businesses easily. Would there be any further recommendations here on?
So I think the rules have to align with the overall codes and the legislation. So I think it's very clearly laid out that we are looking at, decriminalization. So exact provisions around that is something which we will be working with them. And then, of course, the tech-driven inspections that they're talking about, which brings in a lot of ease of doing business, which wasn't there, before, which means a lot of trust-based regime, which is kind of, being envisaged to being worked upon under the labor code. And, we also need to stay, again, what Pooja also said is that the alignment with the states on these rules, because while the basic code will be provided, since it is also state subject, what kind of rules will emerge at the state level? I think that's where we probably need to work a lot and understand, the commonality across, and hopefully, the implementation will not get, impacted by different rules at different states. So I think that alignment is very important from the industry point of view to have the real ease of doing business being enabled.
Right. And Ramani, if I were to ask you about how difficult would it be to implement? Yes, states have will have some legal leeway to make modifications, make changes, or work according to their wishes. But for example, issues such as pay parity for women, gender parity or in wages, would there be certain guardrails, certain penalties to ensure that whatever is written in the code is implemented in letter and spirit?
Yeah, we have to see the guidelines on how these things have to be implemented. But my understanding is that as long as the company or the entities are giving equal opportunities, irrespective of gender, and maintaining pay parity, so I don't think that would be, again, construed as any kind of deviation. But the main issue in terms of implementation would be the huge increase in costs for entities who are currently not complying or who are way below, especially in terms of PF computation and gratuity provisions. So there can be a substantial increase in their overall labor costs, especially if we take MSME segments or the industries or sectors which hire a large number of unorganized labor. What I mean by unorganized labor is any workforce which is not fully compliant with all the 44 labor laws, 29 central laws, as well as the rest state laws. So for those workforce, there'll be an increase in labor cost, maybe up to 20 to 40% as well. So how are these industries and segments going to absorb this increase in cost? Are they going to pass it on to the employees? If that's the case, there can be a drastic drop in their take home. So these are the nuances which are much more difficult to deal with at ground level.
Right. And finally, let me go across to Pooja. Pooja, now in the next 45 days, what are some of the changes that companies will have to implement? And from an employee benefit point of view, what are some of the enhanced benefits that employees could see in terms of greater contributions towards PF, gratuity?
Right. So let me start with what, companies would need to go back. So first and foremost is to look at, the wage and the remuneration structure. The CTC, as, Ramani also mentioned, that will need to be re-looked at, and one might need to go back to the drawing board to see what's the cost impact. Given the change of the definition of wages and it being uniformly now used across all four codes, which was a little fragmented in the current legal framework, this impacts how one is going to calculate gratuity, provident fund, ESI, bonus, and leave encashment. These are your main statutory payouts. For those, who have been calculating provident fund as per the, definition of basic wage under the PF Act, I think there is not much movement there because you are either already calculating it in the right way, which is within, the definition of wages, or like a lot of companies do in terms of provident fund, they base it on the minimum threshold of 15,000. So there again might not be as much of an impact for those who are already complying with that. Now, when we look at bonus and leave encashment, or even retrenchment compensation, speaking academically, one needs to look at the gross wages. Now, there, I think market practice has been a little varied, where, organizations have focused on only basic pay. And that may then change going forward. One will have to look at the definition of wages, see whether you meet the 50% threshold. If not, one plows back whatever is the excess from the from the allowances, right. And that's the reason why one goes back to it. So that's the first thing. Right. Policies, of course, processes, HR processes, of course. So these are few other aspects that, companies should start looking at immediately.
All right. Thank you very much, Jyoti, Vij, Pooja, Ramchandani, Ramani, Dathi, for joining us on the program. A very important issue, and of course, there will be more clarifications in the days to come, and the government will be engaging with the industry before the final rules are published. With that, it's a wrap on this edition of Newscentre. More news and updates continue right here.